As I mentioned before, the topic this month is record keeping, which has been a hot topic in the occupational safety and health realm in the past couple of years. Let's get started with some introductions and introduce you to the voices you'll be hearing today. To start off, my name is Amanda Stranis-Walker, and I'm an OSHA attorney with Conn Maciel. My practice focuses exclusively on OSHA and process safety management issues under EPA's risk management program and includes all facets, rulemaking, compliance assistance, and handling enforcement issues. I've not run into anybody else that has been an OSHA attorney for their entire legal career. Immediately after law school, I went into the Assistant Secretary's office in Washington, D.C., the Assistant Secretary for OSHA, and then made a stop at the Solicitor's office where I continued to focus on occupational safety and health issues before moving over to private practice. I'll go ahead and let Dan introduce himself.
Great. My name is Dan Deacon, and I'm an associate here at Conn Maciel Carey in both the OSHA Workplace Safety Practice Group and the Labor and Employment Group. I represent employers during inspections and investigations conducted by federal and state OSHA. I also advise and counsel employers in responding to notices of employee safety complaints and citations. And on the labor and employment side, I represent and advise employers in all aspects of the employer-employee relationship, including wage and hour disputes, claims of discrimination, etc. And I also review and revise employee handbooks and workplace policies and procedures. So with that, I'll turn it back over to Amanda to go over the agenda, and we'll get started on the meat of the presentation.
Excellent. Our agenda today is broken down into 4 different categories. The first one is the injury data and e-submission requirements, and we'll give a little update on where that process stands at this time. And then Dan's going to talk a little bit about the anti-retaliation elements of the rule that were part of the same rulemaking. And we'll both talk a little bit about the future of both of where these provisions are going. And then we will touch on the fate of Volks, the statute of limitations rule, and one of the last, I think the last, record-keeping rulemaking under the Obama administration. So with no further ado, let's go ahead and jump into the first topic. Improved tracking of workplace injuries and illnesses. As I was sitting down to jot some notes on talking points with regards to this subject, one of the things that I think makes this topic, it's certainly been covered in the last 2 years quite a bit, but one of the things that makes it so interesting to me at this point is we don't really know what's going to happen to it under this administration. The majority of this rule developed under the prior administration, the Obama administration, and there was an assistant secretary who served during that tenure, Assistant Secretary David Michaels, who was very interested in rule keeping. One of the first initiatives he had when he walked into office was a national emphasis program on record keeping. He had a belief that there was widespread underreporting going on in the field. I don't think that national emphasis program, the data from it, actually supported that belief, but nonetheless, he continued his interest in the subject area that resulted in some other changes. One that you probably are familiar with is the new reporting requirements. Employers now have to report amputations, hospitalizations of one employee, some eye injuries, and other sorts of medical conditions that had not previously been required. Prior to that, it required 3 or more employees being hospitalized or fatality. And I should also note that a fatality is still something that you would have to call in and report to OSHA. And it's, part of the topic, he continued on with record keeping in the rulemaking capacity and has made several changes to the rule, one of them being the submission of injury and illness data electronically to OSHA. So electronic injury and illness data submission. And just jumping in on this topic, this is something that many of you are already familiar with, since shortly after OSHA's creation in the early 70s, employers have been required to keep record-keeping documents on injuries and illnesses in their workplace. And, this was typically done by the safety and health director or the HR director. They could use a form that OSHA published on their website or another form that had basically the same equivalent information or captured the same information. And when there was an occupational injury or illness in the workplace, you would get the forms out, you would add them to the add the new entry to your OSHA 300 log, and then you, based on information in your OSHA 301, and then at the end of the year, you would complete your annual summary. A lot of times that information stayed in the HR director's office or the safety director until it needed to be, the 300A needed to be posted at the end of the year. As far as access to that information, it would basically, if OSHA came on site for an inspection, they would ask for that information and employers were obligated to get it. The information could also have been requested through a Bureau of Labor Statistics collection process where they gather information from employers to come up with their statistics, or OSHA also had a OSHA Data Initiative. ODI was what it was called. It's no longer in effect at this time, but they would also send out their own surveys and collect information from employers so that they could figure out DART rates in high hazard industries to target their enforcement dollars. So, previously this was a form you kept in your office. You didn't have any other requirement to make it public other than to post it on your wall, your summary, your 300A at the end of the year, or if somebody did request information with regard to it, the employee or a union organization. So this rule took what was taking place for a number of years and now was going to require employers to proactively or require them to submit their data to OSHA in an electronic portal that's supposed to be available on their website. And the individuals that are going to have to electronically submit their information were establishments with 250 more workers would have to submit their annual summaries, their OSHA logs, and their 301 incident reports. And then establishments with 20 or more workers in high hazard industries would have to only submit their annual 300A summaries. That was kind of the two major categories of employers that would have to submit information. It should also be noted it's only employers that are required to already maintain record-keeping forms. There's some exemptions for some low-hazard industries, and if you weren't already required to keep the paper version of the documents, the electronic submission would not apply to you. Basically, only the employees that are required to keep the paper documents would be subject to the electronic filing submission if they fit into one of these two categories. And we'll talk a little bit more about some of the definitions that are wrapped up in these categories. One of the most frequently asked questions that we faced immediately after this rule was published back in the spring of 2016 was how to count the employees. OSHA bases the employee counts based on establishments, and establishments is a definition that comes out of the OSHA record-keeping rule. It's nothing new. It's been in effect, and it often guides how employees divide up their business and how many record-keeping sheets they have, whether they keep it by each physical location or they might have two locations in close proximity that are gauged in the same type of business that would basically be part of the same NAICS code, and they might, for logistical reasons, keep them on the same record-keeping sheet. But primarily, I think the majority of employers that we see do it location by location, and that means physical establishment, which follows OSHA's definition of establishment. So you're looking at a physical establishment, the bricks and mortar place where employees or where they're designated, where you would already keep their record-keeping information on the sheets. And then you have to determine what the peak number of employees is there during the highest season. So, for example, in the grain handling industry, that might be during harvest season. You bring on temporary workers or seasonal workers, or in a business that is very busy in the Christmas time period. Whatever your highest number of employment, and that includes temporary, seasonal workers, and part-time employees, whatever that number is, the highest number for the year, is going to determine whether you fit into the number criteria for an establishment, and that would lead to your reporting electronic submission of record-keeping information. Moving on, the applicable employee count requires location by location assessment. At each particular location, whether the number meets one of the reporting thresholds, and then, as mentioned, for if you're under the 250 number, that would be for all corporate entities above 250. They have the electronic submission requirement applies to them. But ones that are less than 250, so the group that is between 20 and 249, have to be part of a high hazard industry. OSHA has looked at DART rates, and I believe the DART rate that they went with is if an industry, not necessarily a particular location, has a DART rate above 2, they selected it as a high hazard emphasis or a high hazardous industry for purposes of submitting record-keeping data. The easiest way to determine if you fall within that category, if you are within that number group of 20 to 249 employees per location, is OSHA's record-keeping page has a list of all the NAICS numbers that apply or they consider to be high-hazard industries. So in other words, if you have 49 employees and you fit within one of those NAICS codes, the submission requirement would apply to you. Another question, and I actually get a lot of confusion about this myself, NAICS codes can vary from location or establishment to establishment. You might have a corporate headquarters that is engaged largely in administrative tasks, where a workplace is engaged in some other more manufacturing task. And so you're going to go with the type of work that is done in each location. So if you had 49 employees that are in an office setting at one location or establishment, you, unless that NAICS code is on the list OSHA provides, and I'm pretty sure that it's not, you would not have to submit. But if you had the same number of employees at a manufacturing facility down the road and you maintain separate record-keeping forms for them, you would need to submit those electronically. Just to kind of give you a scope of how this rule, the implications and the amount of data that OSHA will now have access to. So basically, this rule quadruples the number of employees required to submit injury data to Department of Labor. As I mentioned previously, the data that was collected before primarily came in two forms: surveys from Bureau of Labor Statistics or part of OSHA's Data Initiative program, where they would also send out surveys. And so OSHA estimated in its rule that the number of establishments on an annual basis that were impacted by those two surveys was 38,000. So employers that had over 250 employees, data was sought from approximately 38,000 employers out in the field. That's compared to 160,000 employees that had establishments of 20 or more employees. Now those numbers are going to substantially increase, and you can see them here on the slide. So for establishments that had 250 employees, that number of 38,000, OSHA is now going to have access to about 129,000 sites, information that they will be able to look at and have used to, well, OSHA hasn't been incredibly clear on what they're going to use this information on, but, enforcement dollars where to spend it or focus areas. And then that number from 160 increases to 440 for the employers that are 20 and more. The other bullet point that's pretty significant on this slide is not only do they receive the annual summaries, but they'll also receive the OSHA logs, the 300 log and the 301 incident reports for case or from employers that have 250 more employers starting in 2018, and that's almost 1.3 million more pieces of information than what they previously had access to, which just provides a mountain of data for OSHA. OSHA's not been known as a data-savvy government organization, so this is just a big jump in what was currently available to them. And, a lot of questions have been posed whether the tools are in place for them to effectively use it and to effectively protect it, coming from the regulated community and the employers. How the submission process is supposed to work. OSHA is supposed to have a portal available on a website, on a secure website. Doesn't matter if each independent establishment submits the data or if the headquarters submits each establishment's information, but they do have to be part of separate submissions. OSHA has committed to attempt to scrub employee identifying information. One of the major concerns that was brought up during this rulemaking process with regards to the collection of OSHA data logs, so the 300s and the incident reports 301, is the private medical information that would be available from included about employees. And so OSHA has made a commitment to scrub that. The scrubbing process is supposed to be a computer program. There's not been a lot of details about it, but there's certainly a lot of nervousness about it and concern. And even if you were to take an individual's name away, I don't know that this computer program is going to be scrubbing details such as, this was a forklift operator who did something, or a janitor. There might be only one janitor or only one forklift operator at a particular facility, and it wouldn't take a rocket scientist to figure out what employee is being identified by the injury summary. So lots of concerns with regards to that that have not really been sufficiently addressed. The employee identifying information doesn't go into effect under the current regulatory structure until 2018, so certainly some more time to talk about that and see how OSHA intends, if they ever decide to collect it, deal with that. And we'll talk a little bit more about the dates, but July 17, OSHA is to begin publishing employer-specific information online. So OSHA has committed to scrub employee-related information, but is pretty committed to publishing employer-specific information online. So that would be the employer's name, their number of injuries that they had at a particular site, number of hours worked, basically all the information that's on your 300A summary. And I should further clarify this. It was the previous administration that was very committed to publishing it. The rule itself does not actually require OSHA to publish it. That was just the identified and verbally communicated intent of the prior administration, which is no longer in office. So OSHA is certainly currently without a assistant secretary or leadership on how to deal with this, but I think that there could very well, be some changes coming with regards to the intent of publishing it. Going on, this is a quote that came from the prior assistant secretary with regards to the intent of this rule. And he was pretty straightforward about this rule and what its intent was. Our new rule will nudge employers to prevent work injuries to show investors, job seekers, customers, and the public they operate in safe, well-managed facilities. Access to injury data will also help OSHA better target compliance assistance and enforcement resources. There wasn't much disguising the agenda with regards to this. It kind of continued along with David Michael's theory about press releases and public shaming, and I think that this was just another vehicle for that public shaming mission to continue. So that was in the press release when this program was announced. And, there was a notice and comment rulemaking with regards to this, which basically allowed employers to comment, vocalize any concerns that they might have, and bring forward problems with implementation. And, a lot of employers brought forward the inverse impact of publishing data could have on their business. These are just a list of some of the things that we saw in comments: discouraging customers from doing business with them. If you're looking for a roofer, you might just go on and log on to see what sort of injury and illness history they have, or any other individual or service you're looking to hire. Thwarting contracting opportunities with customers. This would certainly be a factor in the federal contracting realm, but also just in private contracting with services to a refinery or anywhere else. Providing ammunition to competitors and an opportunity, maybe a segue for organized labor to begin or interest employees in getting to the bargaining table. Scaring off current and prospective employees, eliminating access to business loans. Bankers now will theoretically have a new source of information that they can go and do research on somebody before they hand out a loan. And then negatively impacting insurance coverage and rates. If you're going to a new worker compensation insurance company, I would certainly think that they would be looking for that information, and, existing ones might be pulling that information as well. So these are all the negative impacts that we were hearing from the employer community, and I think they're very legitimate concerns that they brought forward during the rulemaking process that OSHA didn't really give a lot of credence to. They continued to move forward with the rulemaking, and it was published back in March, and so it had some delayed effective dates that are just around the corner now from its initial publishing. So the first submission that is required under this rule would be the 300As for establishments with 250 or more employees, and establishments with 20 to 249 employees in high hazardous industries. And that is theoretically due on July 1st, 2017. That was the date that was published in the rule that was issued in March of 2016. And as the year follows, the information that would be submitted in July of this year would be the 2016 data. So it would have been the 300As that were posted at the beginning of this year. Next year, we're going to be adding to that requirement, and that would be 2017, and this is what, under the rule that is currently a final rule and in effect today, you would also be adding 300 logs and 301As, the incident summary reports, for employers with 250 or more employees. And then the lower segment of the employers that have the 249 to 20 employees would only continue to have to submit the 300As. So that is what the current effective dates are for the submissions. However, one issue is there's not a portal for employers to submit this information, and we've been getting a lot of questions about that, and I'll talk about that in just a second. Just kind of a continuation of the stakeholder criticisms. There was really not a lot of justification why the electronic submissions were required. Usually in an OSHA rulemaking, there will be a justification and a need for a rule or a standard. This didn't really identify a gap that existed or an increase. One thing that was also brought up, now that this information is going to be made publicly available, or that's how it was indicated what was going to be done with it under the prior administration, would increase the risk of under-reporting. Now that employers know that their information is going to be available on the World Wide Web, they might be a little bit reluctant to put some entries on there, so could result in under-reporting, which is the problem that David Michaels first set out to solve with his National Emphasis Program. Harms relationships with current and prospective employees. Could potentially be a source for civil lawsuits. Civil attorneys looking for potential plaintiffs, that might be something for them to look through. And it undermines OSHA's no-fault injury reporting requirements, or the theory behind OSHA's record-keeping program. That, even if there is a incident in a workplace that an employee had an injury because they were under the influence of drugs or a klutz or whatever it may be, that would still go on your OSHA reporting form. So that would be now available for the entire industry and for all individuals to see without further justification or explaining the background details on a fall or a slip or any other incident that might happen in the workplace. And the rule, with each OSHA rule, there has to be an estimation on the amount of money that it's going to cost employers to comply, and a lot of stakeholders criticized that that was not a fair calculation in the rule, the proposed rule, or the final rule on what the burden on stakeholders was going to be to actually comply with this rule. So this is the rule that is in effect today. As I mentioned, what makes this subject one of the most interesting is to see what this administration does with it. It was certainly a high priority for the previous administration, and it's going to be interesting to see what happens to it under this administration. Just to give kind of a status update, the legal challenge field, this rulemaking was legally challenged. There is a court case in Texas, and it is currently proceeding through the process. The plaintiffs did file a preliminary injunction request, and that was denied in December. That basically allowed for the rule to go into effect. The judge found that there was not sufficient irreparable harm at the time of the filing to prevent the rule under the preliminary injunction standard. He didn't say that, he did indicate that his determination on the preliminary injunction should not be reflective of the final outcome. So the case continues through the process. In the meantime, OSHA has continued to put together, primarily started I think under the prior administration, a data system to collect the submissions that are due in July. A third-party technology company was involved in coming in and developing it and putting it together. And we understand that some private employers have been asked to test the system and see how it works. It's our understanding that it is currently available. It's just waiting for the new administration to see how they're going to handle the rule. OSHA keeps saying check their website on the electronic submissions, and it's, originally there was a date that it would be available, the electronic submission system would be available in February of 2017. That date has come and passed, and there's still not a portal for employers to submit data. And at this time, there's actually no expected date. So we are looking at a July 17th due date with no way for employers to comply. And leads us all to believe that we're going to see some sort of expected delay. There's going to be some delay with regards to the requirement to submit, or possibly a rulemaking to alter the rule that it actually has to be submitted. So as this administration continues to proceed, it'll be interesting to see where this finally ends up with regards to the submission requirement. But as of today, the submission requirement is in effect, and employers are required to submit data by July 1st, 2017. So, however, there's not a mechanism for them to do that at this point. So we'll certainly keep our blog updated if there's any changes, or if a data submission option from OSHA is publicly announced or made available for employers. Turning it over to Dan at this point.
Great, thanks Amanda. This is Dan Deacon speaking, and I'm going to be talking about the anti-retaliation elements of the electronic record-keeping rule. As you all are acutely aware of, that this has been a hot topic in the OSHA circles dating back quite some time now, but especially May 2016 when the rule was published. So we're officially at pretty much the 1-year anniversary since the rule was published. And as you know, it calls into question several employer policies and programs, such as reasonable reporting procedures, post-injury discipline policies, post-incident drug testing, and safety incentive programs. And we're going to touch on each of those in the remaining slides we have here. On this slide, we just want to give you a high-level overview of what employers need to do under the final rule. And as of December 1st, 2016, employers need to inform employees of their right to report workplace injuries, inform employees of their right to report work-related injuries free from discrimination or retaliation, and employers need to update internal injury reporting policies to remove unreasonable elements. In other words, any policy that may discourage employees from reporting injuries. And this was largely in response to universal complaints that the rule would lead to underreporting or underrecording. And as you know, this rule drew sharp criticism almost immediately from industry. 9 industry groups filed a lawsuit back in July 2016 challenging the anti-retaliation provisions, and an emergency motion for a preliminary injunction was simultaneously filed with that complaint, but that was denied back in November 2016, sometime around Thanksgiving. So as of right now, the anti-retaliation provisions are currently in effect, and that was as of December 1st, 2016. The anti-retaliation provisions themselves were written pretty broadly and they're vague, and although there's some guidance that's been issued, it really hasn't been all that helpful. Specifically, shortly before that motion for a preliminary injunction was denied back in November, OSHA issued a guidance member in October 19th, 2016, addressing to some extent what OSHA intends by reasonable reporting procedures and what type of employee discipline, post-incident drug testing, and incentive programs would be considered retaliatory. OSHA also published about a month later, in November, on November 10th, 2016, an interim enforcement guidance that included information on the anti-retaliation provisions, which actually directed investigators to refer those cases to the Whistleblower Protection Program. Note, however, that the guidance there doesn't really address employer policies that have a retaliatory effect, such as those reporting policies, drug testing policies, and also safety incentive programs. All it really says is that drug testing policies or employee benefits under a compensation or incentive program may constitute a violation, but it's going to be a fact-intensive inquiry. So in other words, it really didn't provide us much guidance at all on how some of the more controversial provisions are going to be enforced. Even more recently, OSHA took further steps to try to insulate its efforts to combat retaliation when it issued guidance that was titled Recommended Practices for Anti-Retaliation Programs, and that was issued pretty much a week before President Trump's inauguration, and it was intended to help employers create effective anti-retaliation programs for their workplace. This document pretty much details how employers can implement a program based on, there was 5 key elements, and that's management, leadership, commitment and accountability, a system for listening to and resolving employee concerns, a system for receiving and responding to reports of retaliation, training for employees and managers, and some kind of program oversight. So it would be wise to take a look at that guidance. It's the most recent, and at least it sets up a framework of what an anti-retaliation program may look like. So the new rule added paragraph B1(4) to 1904-35 to prohibit retaliation against an employee for reporting workplace injuries, and this is actually a prohibition already explicit in Section 11C of the OSHA Act itself. However, under the new rule, an employer can be cited just for having a policy that can have a retaliatory effect. No whistleblower is actually required or necessary, and that's at least how it's written. According to the regulation itself, employers must have a reasonable reporting procedure. The rule doesn't define reasonableness, though, and OSHA hasn't explained that either in the preamble or through the guidance. The October guidance, however, did give us a little more insight into what OSHA means by reasonable reporting procedures. However, starting with the preamble, that made clear that a policy that either requires immediate reporting of an injury or a policy that creates an undue burden on employees to complete a report violates this new requirement. Additionally, discipline for violating vague workplace rules such as work safely, those are going to be scrutinized a little more closely, especially if that discipline is dished out only after an injury is reported. As for that October guidance that I mentioned, that gave us a little bit more insight. So, for example, reporting, the October guidance stated that reporting policies with a hard reporting deadline are going to be scrutinized closely because they may deter employees from reporting. Such an example would be reporting within 24 hours or face discipline. Additionally, it wouldn't be reasonable to discipline employees for failing to report an injury before they realize they have a reportable workplace injury, or in instances when they're incapacitated. What employers can do, however, is implement policies that require employees to report an injury or illness as soon as practicable after realizing they have a reportable workplace injury. And that may be the next business day when possible. The key inquiry here is really whether the employer's policy provides some amount of time to report after the employee has realized he or she suffered a workplace-related injury or illness. With respect to also workplace safety rules, discipline for violating legitimate workplace safety rules is not prohibited, right? OSHA ultimately bears that burden to prove that the actual reason for the disciplinary action was that the employee reported an injury or illness, as opposed to the violation of a legitimate safety rule. So the central inquiry there is going to be whether the employee treats other employees who violated that same safety rule in the same manner. So, in other words, disciplining them even if those employees did not report a workplace-related injury or illness. So ultimately, the employer is going to need to ensure that disciplinary action is doled out consistently and imposed for a legitimate reason. Move on.
I just wanted to, we just got a question, sorry to interrupt, Dan, but we just had a great question, and I think this is probably going to be of general interest to everyone as we continue to discuss these anti-retaliatory provisions in the rulemaking. One of the questions, have any of the citations been issued under these anti-retaliation guidelines? I'm not aware of any actual citations that have been put forward. I can tell you, though, that I am aware that OSHA is investigating them. I heard a number where there's something like 60 investigations related open to this. So I just wanted to point that out with regards to that as you listen to these power slides. Certainly OSHA is taking it seriously. They're going out and conducting the investigations, and we can talk a little bit more about some of the challenges that they're having with them, but I thought it might be important perspective to hear what the actual status of it is.
Sure, great. And yeah, we can touch a little bit more on in a couple slides here. I think, Amanda, you're going to jump in and talk a little bit more about the investigations and potential for citation in a little bit here. But we'll continue with the drug testing. The rule snuck in provisions relating to post-injury drug testing, and we get a lot of questions about this. This has been a pretty hot topic for employers that a lot of people are interested in. Basically, the rule states that drug testing may, post-injury drug testing that may dissuade a reasonable employee from reporting a workplace injury, that's not going to be permissible. The main message here is basically that post-injury drug testing can't be used as a form of discipline. One thing is for certain here, though, is that blanket post-injury drug testing policies are strictly prohibited. With that being said, as you see on the screen here, the rule still permits a number of drug testing, including post-incident, if there's a reasonable basis to believe drugs or alcohol contributed to that accident. But as you see, pre-employment drug testing, random drug testing are still permissible. Also, drug testing to comply with state or federal law, for example, complying with DOT mandatory post-accident tests for drivers, and also when required by workers' compensation insurers, and that includes premium reduction policies for post-accident drug testing. So the key here that you can decipher from the rule is that post-incident drug testing may be used as a tool to evaluate root causes of workplace injury. Remember that the rule, it only prohibits drug testing employees for reporting work-related injuries without an objectively reasonable basis for doing so. So to be compliant, there should be some reasonable possibility that drug use by the reporting employee was a contributing factor to the reported injury or illness. There doesn't need to be a reasonable suspicion of alcohol or drug use in the specific incident, just that drugs or alcohol are a reasonable cause for the type of incident, and that's a significant distinction. So the central inquiry and evaluating whether an employer has a reasonable basis to believe drugs or alcohol could have contributed to an injury is based on 4 factors, and the 4 factors that you see on that screen. The first one, which is a little circular, whether the employer had a reasonable basis for concluding drug use could have contributed to an injury. Second, whether the other employees involved in the incident are also tested. 3, whether heightened interest to identify drug use because high hazard work tasks. And 4, whether the drug test is capable of measuring impairment at the time the injury occurred. So if we take a specific example here of requiring a post-accident drug test for a forklift operator who's injured in a crash, especially if there's evidence of reckless operation of the truck, that's going to be permissible. Conversely, if OSHA came across a post-injury drug testing situation for an employee that worked outside after reporting an allergic reaction to a bee sting or something similar, testing a musculoskeletal disorder or a repetitive strain, that's probably going to be suspect and impermissible. What I'd like to point out here, though, is that one of the trickier parts of this drug testing limitation is the nature of the test itself. The preamble to the final rule talks about only allowing testing that can accurately identify impairments caused by drug use, and that makes sense for alcohol testing, but other drug testing doesn't really work in that same way. So further clarification from OSHA is going to be necessary on that issue, or better yet, even from the judge perhaps in the Texas case that's hearing the challenge to these limitations. So we have an example here on the slide that was actually provided by OSHA, where it was in the October guidance. So under this example, they said with a crane accident that injures several employees working nearby, but not the crane operator, him or herself, the employer wouldn't know the cause of the accident, but there's a reasonable possibility that it could have been caused by operator error or by mistakes made by the other employees responsible for ensuring that the crane was working in a safe condition. In that scenario, it's going to be reasonable to require all employees whose conduct would have contributed to the accident to take that post-incident drug test, whether or not they reported an injury or illness. It's going to be appropriate in this circumstances because there's a reasonable possibility that the results of the drug testing could provide the employer insight on the root causes of the incident. However, if that employee, if the employer only tested the injured employee here, but didn't test the operator or any of the other employees whose conduct may have contributed to that incident, that disproportionate testing is probably going to be violative of the rule. Let's see. As for the safety and incentive compensation program, the October memo provides a little further guidance on how these programs may operate properly. What OSHA is mainly concerned about here is the chilling or retaliatory effect of an employer's safety and incentive programs. In other words, incentives that are going to deter employees from reporting a workplace injury or illness. So if the rewards or bonuses are going to be based on injury rates or otherwise lagging factors, that's not going to be permissible. In contrast, if it's based on compliance with legitimate safety rules, workplace safety rules, leading factors, that is going to be okay. So if you look at the screen here, we have a number of items that are and are not permissible. So a bonus, for example, a bonus for employees or crew having no injuries over a certain period of time, that's likely not going to be permissible. We give it the thumbs down. The next one, a raffle in the months that all employees comply with legitimate safety rules, like using hard hats and fall protection. That's going to be okay. The next one, rewarding or denying a benefit or bonus based on an injury rate. Again, that's going to be based on a lagging factor, and that's not going to be permissible. And the fourth one here, bonuses for employees observed working safely, reporting on safe conditions, completing safety training, or participating in a safety committee. that's all going to be permissible. Additionally, the last two here address executive and supervisor compensation and bonuses. So frontline supervisors are going to be scrutinized a little more closely than high-end management and executives who are likely going to be sufficiently removed from that potential chilling effect. So the frontline supervisor who's got oversight over the employees, if their annual bonus is going to be tied to an injury rate, that's not going to be permissible. However, a senior manager, an executive, a front office executive, if their bonus is tied to the injury rate, that's likely going to be permissible. It's going to be okay. And as I touched on a little bit earlier in the presentation's beginning, 9 industry groups have filed a lawsuit against OSHA in July 2016 challenging these anti-retaliation provisions. They basically argued that OSHA didn't show that the provisions would reduce injuries and no APA required regulatory impact analysis was performed. That emergency motion for a preliminary injunction that was simultaneously filed with the complaint was ultimately denied, again back around November, around Thanksgiving in 2016. So as of right now, that the full rule is in effect, including the anti-retaliation provisions. Most recently, just to give you an update on the legal challenge to the rule, there was a motion to intervene filed back in February 27, 2017, by the Texas AFL-CIO and the United Steelworkers. They asked the judge to allow them to defend the case, saying that they needed to intervene in case the new administration abandons its defense of the rule. A couple weeks later, on March 17, 2017, OSHA requested a 60-day stay in the case and filed an unopposed motion for an extension of time to file the proposed summary judgment briefing schedule and to respond to the union interveners' request to intervene. And on April 3rd, the judge granted OSHA that 60-day stay until June 5th, 2017. And as of right now, the party's deadline to submit the summary judgment briefing schedule and their response deadline to the union motions to intervene was extended to July 5th. So we're just going to have to wait and see what happens with this legal challenge as it moves its way through the court. And of course, we'll be updating you all on the case on our blog, so you can stay tuned there as well. And so what is the status of the rule? And that's probably what you're all wondering, right? It's pretty clear that this is a controversial rule that's a high target for the new administration. But as of right now, it's currently in effect. And Amanda, you can touch on the action at OSHA right now, actively pursuing violations, although we haven't really heard of any yet.
Right. You know, so as somebody had asked earlier, and I piped in and said that yes, active inspections are going on are looking at these allegedly anti-retaliatory elements. So OSHA is actually finding it pretty challenging in the enforcement context to put together an alleged violation or citation related to one of these factors, because they're finding they're only pursuing cases where they have an employee who has been aggrieved. So even though that employee might not have used the whistleblower avenue, OSHA is still identifying an employee that's been aggrieved before they're, actively investigating a case. And they're also running into problems that it's more of a inquiry related to a whistleblower claim than it is the typical OSHA enforcement, and that the enforcement staff doesn't have the training or the skill set for the whistleblower investigation procedures. So they're bringing in the whistleblower investigators, which is a completely separate office at OSHA, and those individuals actually have a pretty large workload to start with, and then they're being brought into these new cases, and since they're dealing with a 6-month statute of limitations issue, these cases have to be investigated much more quickly than the typical whistleblower case. So I think there's a number of enforcement challenges that OSHA is kind of working through at this point. As I mentioned before, I heard the number around 60 investigations related to anti-retaliatory provisions are currently underway. We're not aware of any citations that have been issued subject to these new requirements, but if anybody in the field is dealing with them, we'd certainly like to hear about those citations, but we're currently not aware of them. So I think it's turned out to be a little bit more of an enforcement challenge than OSHA had originally anticipated or had thought it would be when they were promulgating this rule, which is going to be interesting to see how the new administration handles that and resolves the issue.
Okay, great. Thanks, Amanda. And just wrapping up the slide here, as we touched on the last slide, the legal challenge is ongoing. There's a delayed briefing schedule right now, and DOL has asked for that 60-day stay, which expires in June 5th, 2017. So what can we expect in the future? What is going to happen with this rule? Well, one thing that we have on the first bullet here, the rule is not subject to the Congressional Review Act since it fell out of that 60-day legislative window. So unfortunately, it can't be struck by Congress. Had it been promulgated during that 60-day window, it likely would have been cut, given the strong industry opposition to this rule. But we still think that this is a high target for the new administration, and there's a few ways that the new OSHA could handle this rule. First would be initiating a new rulemaking to rescind the rule. However, as you all know, probably this is a long and cumbersome process that would likely take years to undo. Number two, they could settle the industry challenge to require rescission or a significant amendment to the rule. And a couple of the quicker options that are available to the new administration to curb some of those elements of the rule or its potential impact on employers would be delaying some of the effective dates of the rule. For example, that July 2017 deadline for reporting injuries and illnesses that's coming up. Two, they could issue new letters of interpretation, taking a 180 turn on these views. The unions and others may challenge these actions, but courts have historically deferred to an agency's interpretation of its own regulations. So the immediate effect of a letter of interpretation or new guidance would be to prevent OSHA from issuing citations to employers that have these types of policies that the Obama administration disfavored. Three, they could foreclose enforcement of the rule through a budget rider by simply not allocating funds in the new budget to enforce this rule. So that leads us to what should employers do now? Beginning with the first point here is you should provide refresher training on injury and illness record-keeping requirements to ensure that responsible employees are aware of those new electronic record-keeping requirements in the data submission. Two, you should audit your injury and illness record-keeping forms in preparation for that reporting deadline. And three, you should evaluate and update a number of things, including your injury reporting policies to ensure that they're not that burdensome as to discourage reporting. You should evaluate and update your drug testing policies to ensure it doesn't discourage reporting or to ensure that it does comply with the workers' comp or other legal requirements. And three, you should update your safety, incentive, and management compensation programs to ensure that they don't have that chilling or retaliatory effect. Moving on, we're still covering what else employers should do. So one available option that you have here, since you cannot have a blanket post-incident drug testing policy, is considering that the use of random drug testing. If that's an issue that you're concerned about in your workplace, this is still permissible. It's still an available tool for employers to ensure that the workplace is still safe. Two, here you should post the latest version of the OSHA rights poster, which is available on OSHA's website, and inform employees of their right to report injuries without retaliation and how they can do this, how to report. And finally, Eric, one of our partners, he likes to include this in here, is hide the empty pizza boxes when OSHA shows up, or at least throw the pizza parties for complying with workplace safety rules as opposed to celebrating low injury rates, right? And finally, we're getting into the last part of the presentation here, where we're going to discuss the fate of the Volks rule. And I see we only have 3 minutes here, so I'll try and go through these slides pretty quickly. But as you're all probably aware, this is something that has come up fairly recently. OSHA previously published the final rule clarifying an employer's continuing obligation to make and maintain accurate records of each recordable injury and illness, and that was in December 2016, again shortly before the inauguration. Essentially, this clarified that the record-keeping requirement was a continuing duty, and that the statute of limitations was 6 months plus 5 years, so essentially 5.5 years. The clarification was needed because of the D.C. Circuit's opinion in 2012 in the Volks case. That rule was an effort to overturn that decision, the rule that was published in December, which ultimately held that OSHA could could only cite record-keeping violations within 6 months of the day the injury or illness was first required to be recorded. And that majority opinion was based on an unambiguous reading of the OSHA Act. Section 658C states, no citation may be issued under this section after the expiration of 6 months following the occurrence of any violation. However, OSHA seized on the concurring opinion to support its effort to circumvent this opinion by changing the language of the applicable regulation. And they did this without ever petitioning to the Supreme Court for review or requesting a hearing en banc before the D.C. Circuit. They just promulgated this rule clarifying an employer's duty. So what happened to the rule, though? Well, the election of President Trump and the unprecedented use of the Congressional Review Act, that's what happened. The Congressional Review Act creates basically a period of 60 legislative session days, or days in which Congress is in session, during which it can use this expedited procedure to overturn a regulation, or basically repeal it, cut it out. And since the Congressional Review Act became law, which was back in 1996, more than 120 resolutions of disapproval have been introduced, and actually only one has been successfully used, cut during that time until the Trump administration. And that was actually President Clinton's midnight ergonomics rule that was overturned shortly after President Bush came into office. So the Volks rule was repealed on March 22nd, 2017. Just a couple months ago, both houses of Congress passed a joint resolution bill disapproving of the Volks rule, thereby returning to the post-Volks decision, the D.C. Circuit decision that implemented that strict 6-month statute of limitations for record-keeping violations. And as you can see here, this is a pretty big deal for employers. Just look at the statistics regarding the record-keeping violations. The risk or danger of receiving a record-keeping violation has dwindled pretty significantly between the time of the D.C. Circuit's Volks decision and the promulgation of the Volks rule. Record-keeping violations dropped by 75%. And with that being said, that's the end of our presentation. I just want to thank you for joining us today. And we hope that you all can join us for another interesting discussion on our next webinar, which is going to be June 6th, where we're going to be discussing letters of interpretation and the variance process, and some of the tools employees can use to shape agency interpretations and obtain variances from OSHA standards. And this is especially timely given the new administration's commitment to listening more to the regulated community, so I'd mark your calendars for that one. And you can also follow us on our blog, where we post articles on these topics on a regular basis. With that being said, if any of you guys have any questions, you could post it in the comment section. I realize we've had a lot of questions come in throughout the presentation, and it was we're definitely going to respond to each one of you that placed a question in here. There was a tight window for us to get all this information in, so if we missed a question, we apologize, but we plan on following up with you individually. And with that being said, if anyone else has a question following this presentation, you can contact Amanda or I or anyone in our OSHA practice group, and feel free to reach out.
And with that, we're going to conclude our discussion today, webinar. Thank you very much.